In our last lecture, already we have discussed regarding the very sources of international law. So in this lecture, we would like to discuss on codification of international law. So, as we have found and selected 10 different factors responsible as regarding the codification of international law. So, in that connection, we would first discuss regarding the very meaning and historical contribution of the jurist and theorist in connection to codification of international law. So, exactly if we will find out the very meaning of codification of international law, it is a kind of enactment of an uniform statute by harmonizing of municipal laws of various countries into international law, and it is a systematic restatement of existing customary international law into the formal enactment of international law and also of existing customary international rules and regulations and developing and amending and improving the existing international rules and regulations pertaining to international law. So, in this regard, the Committee on the Progressive Development of International Law and its codification set up by the United Nations General Assembly as per the provisions of Article 15 of the Statute of International Law Commission, which provides progressive development of international law and its codification. But due to certain specific and scientific determination as regarding the scope and jurisdiction of international law, the very achievement of universal acceptance became very difficult as regarding the requirements of different governments, as the requirements of different governments of the member countries of United Nations organizations are so diversified that a common agreement is completely impossible as regarding the existing law is not well settled in the form of customary rules generally accepted by judicial precedents or through enactments. So, regarding the very history and the development of international law through codification, we would like to touch the jurist and the theorist, such as Jurists.Bentham, the 18th century English jurist and legislative reformer who contributed in the very development of international law in regards to codification. So also, why the Austrian international law jurist AlfonsDomin, and also by Professor Francis Liber of Columbian Law School, and also the Swiss international jurist Bluntschli, and also by the Italian jurist Pasqale Fiore in 1819. The attempt he made regarding codification of international law. Also, in 1906, Duplexes published his Code of International Law, and as regarding to certain international instruments, we found that of the Declaration of Paris, which was signed in 1856 regarding codification of international law, among the parties such as Great Britain or United Kingdom, France, Russia, Austria, and Turkey, and also in regards to the attempt made by Institute of International Law in 1873, and also the Brussels Conference and Declaration of 1874, and also we found certain other international conference which contributed for the codification of international law, such as the Hague Conference of 1899 and 1907 on codification of international laws on land war, maritime war, and Pacific settlement of international disputes. So also the London Declaration of 1909 on contraband goods. And now we'll go to another important factor, a contributing factor regarding codification of international law is the codification by regional groups. So all the regional groups, such as, for example, the American Institute of International Law in 1928 held the American Conference on Status of Aliens, Duties of Neutral States, then on treaties, diplomatic immunities and functionaries, consular agents, maritime neutrality, and asylum. So, these are the contribution or contributing factors why the regional groups in regards to codification of international law. And then we want to go to the League of Nations, which was formed in 1920 after the end of the First World War. Due to the intense initiative and effort of the then late President of United States of America, Dr. Woodrow Wilson, and the very League of Nations formed committees on codification of international law in regards to issues relating to nationality, territorial waters, responsibility of a state, diplomatic privileges and immunities, So also regarding treaties, piracy, and exploitation of the product of the sea. And after the formation of United Nations at the end of the Second World War in 1945, Article 13 of the United Nations Charter provided scope for the codification of international law. So, accordingly, the United Nations General Assembly, in its resolution, constituted the first International Law Commission in 1947, and as per the provisions of Article 1 of the Statute of International Law Commission, it made attempts for progressive development and codification of international law, and Article 15 of the Charter of United Nations provided preparation of draft conventions on the subject and precise formulation and systematization of rules of international law. Following rules already been extensive, such as state practice, and also regarding precedent and progressive development of international law by jurists and political functionaries of the representatives of the states who are the members of United Nations Organization. Then codification attempts were taken by the international organizations or institutions in regards to codification of laws on high seas. So, in accordance of that, the Geneva Conference on the Law of the Sea, in its four conventions in 1958, held and attempt at codification in regards to the territorial sea and contiguous zones, so also in regards to high seas, fishing and the conservation of the living resources of the high seas, and also the continental shift, and as it was held in regards from 1968 to 1973, reviewed by the United Nations Seabed Committee on the attempts of codification of laws on high seas by the Geneva Conference in 1958, and a resolution was adopted by the United Nations Conference finally on law of the sea by majority in 1982. And the another attempt regarding codification of international law was in respect of space law. In 1958, a resolution of the General Assembly on peaceful uses of outer space, and the 1959 resolution on international cooperation in the peaceful uses of outer space, and the 1962 resolution on the progressive development of international law on the exploration and use of outer space and to the liability for space vehicle accidents. And in 1963, a resolution was passed on legal principles of governing the activities of state parties in exploration and use of outer space. So also in 1967, an agreement on use of space activities in moon and on celestial bodies, space activities, and another codification attempt on space law was held in 1975 by the European Space Agency's effort, and finally in 1979 United Nations Outer Space Committee Treaty was ratified and came into effect. And also we would now like to go codification of laws on nationality and statelessness. So in 1950, the Commission of the Economic and Social Council of United Nations Organization attempted and made certain codification of laws on nationality and statelessness. So also in the 1953 session, it drafted a resolution on elimination of statelessness and on nationality, and the 1959 International Convention, which was held in Newark in the United States of America, on the reduction of statelessness and to grant nationality, was adopted on majority of the participant states and the signatory to that very conference of 1979. And now we would like to discuss about how codification attempts were made by the International Law Commission. So the International Law Commission, which was constituted by the General Assembly in the year 1947, in its 1979 draft resolutions, it exceptionally attempted codification of international law on succession of states, also on state responsibility, and treaties between states and international organizations. So finally in 1994, the Geneva meeting on International Criminal Court and matters on aggression, crime against humanity, serious violation of international humanitarian law during armed conflicts, genocide, apartheid, and etc. were drafted and codified by the International Law Commission. And finally, we want to enter into the last factor responsible in regards to codification of international law, and that is the Vienna Conventions, So the 1961 Vienna Convention on Diplomatic Relations, 1963 Vienna Convention on Consular Relations, 1969 Vienna Convention on Special Missions, and 1975 Convention on State Representation in international organizations were the milestones in regards to codification of international law through the Vienna Convention. So also in 1969, 1977 and 1978, the Vienna Convention contributed for the codification on law of treaty and also the Universal Declaration of Human Rights in 1948. So also the Vienna Convention in 1951 contributed codification of international law on status of refugees, and in 1973 the Vienna Convention codified international laws on suppression and punishment of the crime of apartheid. And finally, in 1981, the Vienna Convention adopted the Declaration on Elimination of All Intolerance and of Discrimination on the basis of religion and belief. Also, the Vienna Convention, in its attempt to codify international law with the assistance of the United Nations Organization, made certain contribution in codification of certain treaties, such as the Non-Proliferation of Nuclear Weapons Treaties of 1963 and the Antarctica Treaties of 1982, and the very process of codification at international level by the International Law Commission, the United Nations Organization General Assembly, and its subsidiary or specialized agencies, and also why the conventions, the very process of codification of international law is a continuing process. So the codification of international law, which started with the Paris Declaration of 1856 and the Hague Conference of 1899 and 1907, is still continuing, and the very process of codification of international law would be a continuous process. And in this particular lecture we have discussed some important 10 enduring factors which we found are responsible in contributing for the codification of international law. So finally we want to conclude this lecture on codification of international law, as it is a continuing process. So codification always in a continuous process, and it is developing and enriching every aspects of international law.